Hey everybody, John Skiba here, and in this video I'm going to talk about written discovery in your debt collection lawsuit. We're going to talk about interrogatories, requests for admissions, requests for production of documents, and even we're going to touch on depositions. But if this is your first time here to my YouTube channel, go ahead and click subscribe, check on that little bell, that way you'll be notified each and every week when I provide new videos that help you deal with your serious debt problem. Alright, let's talk about written discovery in the context of your debt collection lawsuit. So if you've been sued by a original creditor, Wells Fargo, Chase, Bank of America, or a junk debt buyer like Midland Funding, Portfolio Recovery, Cavalry, whoever it is, many times they will serve on you what's called written discovery. Now, written discovery, what this is the process that's built into a civil litigation suit where the parties can request information, they can request documentation. In the form of requests for admissions, they can ask you to admit or deny certain facts to try to narrow the scope of what's actually in dispute. And so this can be used by either you or the creditor to gather information or documentation. Now, the first thing I want to talk about is when the creditor sends the written discovery to you as far as you responding to it. Because this is very important, because a lot of people, they'll serve you with written discovery and either you don't respond to it or you don't respond to it correctly, and then it causes you problems down the road when you get into like a trial or summary judgment. Now, there are really three different avenues for written discovery. They can send you what are called requests for admissions. This is where they're asking you to specifically admit or deny a fact. There are what are called interrogatories. These are essentially written questions asking you in long form to explain certain aspects of the case or respond to a request for information that they have. And then the third area is requests for production of documents. This is when, exactly what it's saying, they're asking for specific documents that they're wanting you to provide to them. Now, if you're trying to look these up in your individual state, there are rules of civil procedure that correspond to each of those specific requests. It governs usually how many of these requests they can send you, how long you have to respond to them. It's a good idea to look them up, and you can just go to like Google Scholar and type in, requests for admissions, Arizona or California or Florida or wherever it is that you live. Most of them will correspond with rules 33, 34, and 36. That's how it is in Arizona. Most states are based, their rules of civil procedure are based on the federal rules of civil procedure, and those are 32, 34, and 36. 33, 34, and 36. So you may want to take a look at those, but there are different response times in different states. For instance, even in Arizona, the difference between Superior Court and Justice Court, sometimes you have 40 days to respond to it, sometimes you have 30 days to respond to it. So you're going to want to make sure if you've been served with a request for production of documents, request for interrogatories, or request for admissions, you want to make sure how much time you have to respond to it. And I'm going to talk about the main reason first here. This is one of the most important, is because there are penalties sometimes that can be really onerous if you don't respond to them, particularly with requests for admission. So the request for admission will often be something pretty simple, like admit that you owe Midland Funding $4,233 or whatever it is. And then literally it'll have like a admit or deny and kind of a check the box kind of thing. And if you don't respond to that timely and provide a copy to the other side, in most states the rules will deem you to have admitted that certain fact. So if you just don't respond to it, if you blow it off or you think you don't know what to do, there are certain situations where then they can take those requests for admissions, they can attach them to a motion for summary judgment. I've seen them do this and say, look, judge, they didn't respond to this. The law says, therefore, they've already admitted it, and then you can lose on that. So requests for admissions in particular, you need to look up the rule in your state, find out when they're due, and you need to make sure that you complete them and send a copy to the other side and do it timely, or that can cause you some problems. Again, that's generally Rule 36 with most states' rules of civil procedure, but I know some states have a different numbering system, so just go to Google Scholar, search that, you'll be able to find it. So now let's talk about responding to a request for admission. When you look at it, the important thing in responding to any written discovery, you need to be honest with this. You need to be completely forthright with the information that you're providing. That being said, when you look at the questions, you need to realize that a lot of times the attorneys who are drafting these, they're drafted really poorly. So, they may ask you to admit that there is $4,292 that's due to Midland Funding or even to the original creditor. If you don't know how they calculated that specific dollar amount, you can either object to it and say that you don't know how they calculated the dollar amount, or even deny it and say, I don't know. Unless they provided you with a true calculation that you've independently checked, something like that would be okay to deny because you don't know how it is that they calculated it. Another question they often ask is admit that this debt was transferred from the original creditor to the junk debt buyer. Unless you know that for sure or they've proven that, I think my opinion is you can honestly deny that because they haven't proven that at that point. Let's jump to interrogatories. Now, interrogatories, they're kind of like an expanded version of the request for admission. So they're asking for more than just admit or deny. They're asking for kind of long-form information. There are certain areas that are protected. A lot of times what they're trying to do here is not only get information for the case, but they're trying to get information from you. So in the event that they get a judgment, they can collect against you. So often they're asking for things like social security numbers, your employer's information, bank account information. If something that they're requesting is not really relevant to what it is that the case is about, you could raise objections to them. If there's a dispute, the judge can end up deciding whether you have to turn over the information. But if there's something that's just totally not relevant, if they're asking for your daughter's checking account information or something, obviously something like that is completely irrelevant and you can raise an objection to it. Otherwise, you can provide them the information that they're needing and submit that back to them. The third area is request for production of documents. Now, I can tell you in most clients that I deal with that are being sued by debt buyers, they don't have a lot of documentation. And truthfully, I don't see a lot of requests for production just because, they may ask for some statements or something like that from the original creditor. Typically, these cases are multiple years old and, nobody keeps those things. So if they do request documents and you have them in your possession, then you are required to turn them over. If it's not something you can obtain or something that you don't have, you're not required to do that, and you can raise an objection to it saying, I don't have this, I don't have access to it, there's no way I could get that document. So that's the important thing in responding to written discovery that the creditor is serving on you. Again, the biggest one you need to highlight is requests for admissions. If you don't respond to those timely, it can just deep six your whole case. Now, what about you? You sending over requests for them. We see this quite a bit where people are wanting to request additional documents. They want to request additional information. They want to do requests for admissions. I would probably steer you to a video I did a little while ago under my less is more theory of defending these cases, in that the burden of proof is on the plaintiff. Often they don't have the documents. They don't have the information. They don't have the witnesses they need to be able to prove their case at trial. And so by you requesting additional documents, it may actually kind of backfire because they may have to go back to the original creditor and start asking them to provide information that they didn't have and they wouldn't have had for your trial. So I'd always say be a little bit careful in doing written discovery requests to the opposing party. If you're going to do any type of discovery, I generally recommend that you ask to take the deposition of the witness that they're going to use at trial. Now, a deposition is where you're literally taking testimony. You're asking questions live. Usually there's either a court reporter there or it's being recorded. You want to do one of those two things. You either want to have a court reporter or you want to have it recorded so that you can use it again later in trial. Not only will it help you to know what the witness is going to say when you get into trial so that you're prepared fully as knowing to what they're going to testify to, I can tell you a lot of times when you request to take a deposition, sometimes they just dismiss. Those things can be time-consuming, they can be expensive, they can be cumbersome, and often they don't want to have their witnesses on the record like that because it's under oath, and it can cause them problems down the road. So I've seen cases where attorneys have noticed up a deposition of the opposing party's witness, and the case ends up just getting dismissed from there. So hopefully that'll help you with some kind of tips and strategies as far as dealing with written discovery. The big thing is to respond to the request for admissions timely so you don't get a summary judgment entered against you for failing to respond to those. I hope that was helpful today. Thanks for watching.